Parts of get versus one.
That's for keeping account of what is produced and dispatched. Ultimately, the point of time when the royalty is to be paid is when it is dispatched. It leaves the leased area. What I was pointing out to my laws in part 7, condition 1, is the structure, my lord, that rent, water rate and royalties reserved by this lease at such times in such manner in provided in part 5 and 6 of these presents, and shall also pay and discharge all taxes, rates, assessment and imposition whatsoever.
So taxes are used in
the nature of public demands.
Yes. So taxes are not, royalties are not subsumed in taxes.
No. Even section 25 uses royalty and tax both separately.
That we saw.
And one explanation I gave, my lord, about why only a recovery of tax provision is there, referring to the previous act and the rules. The other is, my lord, that subsequent to this act, the states are still competent under entry 50 list 2 to impose tax on mineral rights. So therefore, and it's the provisions say either under this act or this rule or the terms and conditions of the lease. So the lease condition expressly talks of royalty and tax also, because some state can, other states may not. So as the case may be, that's the expression concern. That completes. Now there are other acts, my lord, which also like Coal Bearing Areas Acquisition and Development Act 1957, where central government in certain states has acquired the land and then it has power to vest it in some central government company also. So that also contemplates the payment of royalty, though it says that you will pay a sum which is equivalent to royalty payable under this act, Mines and Minerals. I'm not referring to your lordships to all those acts because there are a number of acts where this is section 18A of Coal Bearing Areas Acquisition and Development Act 1957, page 1396 at 1404. Under section 10 of this act, the central government can acquire either the land itself or the rights in the land.
Same module.
Section 9. Allow me to place 2 or 3 sections.
Coal Bearing Areas Act? Or?
Yes, Coal Bearing Areas Acquisition.
Where do we get it?
Page 1399, volume 4. Section 9 is declaration of acquisition, where the central government is satisfied after considering report, if any made under it, that any land or any rights in or over such land should be acquired. A declaration shall be made by it to that effect, and different declarations may be made from time to time in respect of different parcels of land or of rights in or over such land covered by the same notification under section 1 of 7, irrespective of whether one report or different reports has been made, provided that no declaration in respect, something like section 6 of the Land Acquisition Act. But the importance of this section is that it is the Parliament is visualizing the land itself and the rights in or over such land differently and separately. They are distinct rights. Even under the MMDR Act, when the lease is granted, so the right to the leased area in the form of lease is by virtue of the grant of lease. But the right to extract the mineral and dispatch it is by virtue of the conditions of the lease. So either of the two can be acquired or both. Then 10 says vesting of land or rights in central government. On the publication in the official gazette of the declaration under section 9, the land or the rights in or over the land, as the case may be, shall vest absolutely in the central government, free from all encumbrances. Where the rights under any mining lease granted or deemed to have been granted by a state government to any person are acquired, under this act, the central government shall, on and from the date of such vesting, be deemed to have become the lessee of the state government, as if the mining lease under the mineral concession rules had been granted by the state government to the central government, the period thereof being the entire period for which such a lease could have been granted by the state government under those rules. So if you acquire only, then you become a lessee of the state government. Then 11, power of central government to direct vesting of land or rights in a government company. Notwithstanding anything contained in section 10, the central government may, if satisfied that a government company is willing to comply or has complied with such terms and conditions as the central government may think fit to impose, direct by order in writing that the land or the rights in or over the land, as the case may be, shall, instead of vesting in the central government under section 10 or continuing to so vest in the government company either on the date of publication of the declaration or on such other date as may be specified in the direction. And then 12 is taking of possession. Now kindly see 18A. Payment to state government in lieu of royalty. Notwithstanding anything contained in this act where any land or any rights in or over land belonging to a state government, other than the rights under a mining lease granted or deemed to have been granted by the state government to any person vested in central government under section 10 or in a government company under section 11. The central government or the company, as the case may be, may pay to the state government such sum of money as would have been payable as royalty by lessee had such land or rights been under mining lease granted by the state government. So if the central government does not transfer it to the company and keeps it to itself and does mining, then it will pay a sum which is equivalent to royalty. Note, and I'm done with this.
Section 16.
This is
Page 4.
4B, the Offshore Areas Mineral Development and Regulation Act 2002. Volume 4B, page 6. Section. Kindly see section 16 at page 13. Lordships have section 16. A lessee shall pay royalty to the central government in respect of any mineral removed or consumed from the area covered under this production lease at the rate for the time being specified in the first schedule in respect of that mineral. Again, it is in respect of any mineral removed or consumed.
Right.
So the question now, my lord, is having seen the scheme of royalty, the fact that a private person pays royalty to the government and the government pays to the private person if the government is mining in an area where the minerals are owned by a private person. I submit that that fact alone is enough to conclude that royalty under the MMDR Act or the other cognate acts is not a tax. Because a tax, my lords, as enunciated by this court, is a sovereign imposition or in public interest to meet the needs of the government. And this has been so held by all the honorable judges unanimously, my lord, in Jindal's case. I'll show that those paragraphs.
Distinguishing between tax and.
Here, on a holistic reason of the act, quite apart from the normal concept of royalty as we understand, is that royalty is being paid to the owner of the minerals, be it government or a private person. Logically, therefore, my lord, since the owner is parting with his right to extract and sell the minerals in the market in favor of a lessee or a deemed lessee under law, therefore, the lessee is required to pay a particular share. The other thing is that for good reasons, the framers of the Constitution have placed entry 54 in list 1 because minerals are of considerable importance to the whole country. And therefore, to an extent, as far as royalty is concerned, some broad uniformity and that's the idea of regulation. That's the entry says regulate mines and mineral development. Before independence, many state provinces were making their own rules and own royalties were being fixed in the way they wanted. So therefore, in the interest of the country, the fact that there is an uniformity envisaged as regards royalty would not mean, my lord, that it's a taxation. The fee can be uniform, the prices can be uniform. So various charges, levies, impositions, they can all be uniform or differentiated. Even the parliament, while fixing royalty, as the lordships have seen in the rules, they can fix different royalty for different minerals. And parliament is also competent to fix a different rate of royalty for different states if it can classify it appropriately. So that idea of classification remains with the central government, and it can do that. So whether it wants a complete uniformity or broad uniformity or differentiated rate of, it's up to the central government. Indeed. But that does not make it a tax. Because one of the assertions from the other side is that since it's a uniform imposition by the parliament under this, so therefore it's in the nature of tax. And for that, they draw sustenance from the word imposed in Article 366(28). Now, kindly see, my lords. Kindly see how India Cement dealt with this issue. Just one more thing, my lords, the lordship may note Schedule 6, the only place where kindly have a lot before the case, not Schedule 6. The only place where Constitution uses the expression royalty is in Schedule 6. Kindly have clause 8 of Schedule 6. Now, this 6th schedule refers to Article 244(2) and 275(1). Please see clause 8. The regional council for an autonomous region in respect of all lands within such region, and the district council for an autonomous district in respect of all lands within the district, except those which are in the areas under the authority of regional councils, if any, within the district, shall have the powers to assess and collect revenues in respect of lands in accordance with the principles for the time being followed by the government of the state in assessing lands for the purpose of land revenue in state generally. 2. The regional council for an autonomous region in respect of areas within such region and district council for an autonomous district in respect of all areas in the district except those which are under the authority of regional councils, if any, within the district shall have power to levy and collect taxes on lands and buildings, which is entry 49, list 2, and tolls on persons resident within such areas. The district council for an autonomous district shall have the power to levy and collect all or any of the following taxes within such districts, that is to say, 8. Taxes on professions, trades and callings and employments, taxes on animals, vehicles, boats, taxes on the entry of goods into the market for sale therein, and tolls on passengers and goods carried in ferries, taxes for maintenance of schools, dispensaries or roads, and taxes on entertainments and amusements. So a set of taxes in 8. Regional council or district council, as the case may be, may make regulations to provide for levy and collection of any of the taxes specified in subpara 2 and 3 of this paragraph, and every such regulation shall be submitted forthwith to the governor and until assented to by him shall have no effect. 9. Licenses or leases for the purpose of prospecting or for extraction of minerals. Such share of the royalties accruing each year from licenses or leases for the purpose of prospecting or the extraction of minerals granted by the government of the state in respect of any area within an autonomous district, as may be agreed upon between the government of state and the district court of such district, shall be made over to that district council. It's interesting that the district court is brought in.
No,
Yeah.
I don't know, is it correct?
no,
Should be district council. It should be council.
Distinction.
Yeah.
The distinction.
If any dispute arises, shall be referred to the governor for the determination.
You see, these areas are autonomous areas, particularly from Assam. So there used to be district courts. So we do not know. We can't be very sure that it's a typo
That's why
or.
I was asking whether all books have. I think. Huh?
District council, but they are district council constituted.
No, it is district council otherwise, because councils are there. So just cross-check whether it is a typo or it should be council. District councils are there, the elected bodies.
It's typographical.
District councils are elected bodies, so far as those areas are
Yeah,
concerned.
district council.
Defined council elected body.
Council.
Has to.
Now, what I'm trying to point out is not that taxing power has been separately mentioned in 8, and royalty is for the extraction of minerals is separately placed in 9. Just a minute.
Volume 5, 115.
Now?
Yes. Having placed, my lord, how the courts have dealt with this issue, just 4 or 5 cases, and then I'll advert to 366/28. Kindly allow me, my lord, to read India Cement and Keshav Ram, my lord, in some detail, my lord, because the
Yes.
conflict is between those
In
two.
any case, that will also
approach of
cover
these two
what they would have
cases.
otherwise.
Yeah. Kindly come to page 1155,
Of
volume 5. From the very beginning, I'm placing the question involved in these. I'm so sorry.
Just a minute.
Hmm? May I please? I think Justice Bhuya is a problem.
Yes, no, it's fine.
The question involved in these appeals, especially petitions and writ petitions, is whether levy of cess on royalty is within the competence of the state legislature. In order to appreciate the question, it is necessary to refer to certain facts. Civil appeal so-and-so is an appeal by special leave from the judgment and order of the High Court of Madras dated 13th October 69. In writ appeal number 46467, the appellant is a public limited company incorporated under the Indian Companies Act 1913. The company at all relevant times used to manufacture cement in factory at Talayuthu in Tirunelveli district and at Sankari in Salem district of Tamil Nadu. By GO dated 19th July 63, the government of Tamil Nadu sanctioned the grant to the appellant mining lease for limestone and concur for a period of 20 years over an extent of 133.91 acres of land in the village of Chinagondanur, Taluk, Salem district, out of the extent of 133.91 acres comprised in the mining lease. An extent of 126 acres was patta land and only the balance of 7.7 acres government land. This lease was in accordance with mineral concession rules. 1960. Similar part of the land was patta land and part was government land.
Two surviving members. In their both on this side.
We have a little bit of connect on this side also.
That's right, that's it. I was about to say that.
Right, right.
Correct, correct.
The last thing. And Chief Justice, ultimately it comes down to this, do we accept the Mysore Patna view? Or do we accept the Rajasthan Patna? That's how it will argue. And the most pleasant surprise on our side was when Mr. Parasaran got up and supported the petition. This time also the union has filed an affidavit.
The rates of royalty, dead rent and surface rent were as follows. Royalty, limestone, all the rates are given. Then the appellant started mining operations. I'm reading para 2. Soon after the execution of the lease deed and has ever since been paying the royalties, dead rents and other amounts payable under the deed. Under section 115 of the Madras Panchayats Act, as amended by the Madras Act 18 of 64, the royalty, the appellant was required to pay local cess at 45 paisa per rupee. It may be mentioned that the said imposition was with retrospective effect along with the local cess surcharge under section 116. The contention of the appellant is and was at all the relevant times that cess on royalty cannot be levied. This may be marked below that the issue is only whether cess on royalty. This is the common question which falls for consideration and requires determination in these appeals and petitions.
Local cess.
To complete the narration of events, it has to be noted that the collector sent a communication on April 10, 1965 demanding cess or royalty payable under the Act on Minerals carried on during the period July 1, 1961 to December 31, 1964, and the petitioner was threatened by serious consequences in case of default of payment on receipt of that communication. Thereafter, writ petition number 1864 of 1965 was filed in High Court of Madras, where the judgment delivered by order so learned single judge of the Madras High Court Justice Kalasam dismissed the writ petition, holding that the cess levied under Section 115 is a tax on land and as such falls under entry 49 state list of the 7th schedule of the Constitution and was within the competence of the state legislature. A reliance was placed by learned single judge on the decision of this court in HRS Murthy versus Collector of Chittor, another constitution bench judgment of Honorable 5 judges. He held that cess levied under Section 15 was a tax on land, though fixed with a reference to the land revenue in regard to Section 116 of the Act. The learned single judge held that the maximum limit had been prescribed by the government by rules, and therefore there was no arbitrariness about the levy. Subsection 1 of Section 115 enjoins there shall be levied in every panchayat development block a local cess at the rate of 45 paisa on every rupee of land revenue payable to the government in respect of any land for every fasli. An explanation to the said section was added and deemed always to have been incorporated by the Tamil Nadu Panchayats Amendments and Miscellaneous Provisions Act 1964, being Tamil Nadu Act 18 of 1964, which provided as follows. Explanation. In this section and in section 116, land revenue means public revenue due on land and includes water cess payable to the government for water supplied or used for irrigation of land, royalty, lease amount, or other sum payable to the government in respect of land held directly from the government on lease or license, but does not include any other cess or the surcharge payable under section 116, provided that land revenue remitted shall not be deemed to be land revenue payable for the purpose of this section. Subsection 2 of section 115 provides that the local cess shall be deemed to be public revenue due on all the lands in respect of which a person is liable to pay local cess, and all the said lands, the buildings upon the said lands and their products shall be regarded as the security for the local cess. Subsection so-and-so of section 115 of the said Act deal with the application of the cess so collected for various purposes mentioned therein. In the controversy before us, the said provisions need not be considered. Section 116 of the Act is as follows. Every Panchayat Union Council may levy on every person liable to pay land revenue to the government in respect of any land in the Panchayat Union a local cess surcharge at such rate as may be considered suitable as an addition to the local cess levied in the Panchayat Development Block under Section 115, provided that the rate of local cess surcharge so levied shall not exceed rupees 250 paisa on every rupee of land revenue payable in respect of such land. The words shall not exceed 2 rupees 50 paisa on every rupee was substituted for the words shall be subject to such maximum as may be prescribed by Section 3 of the Tamil Nadu Panchayat Act 1970. And these words were substituted for the words shall not exceed 1 rupee and 50 paisa on every rupee of land revenue by Section 2 of the Amendment Act 1972. So that's how the matter came up. Now, what is to be noted is not that here the cess which has been imposed is with respect to land revenue, and royalty is one element. If we come back to the explanation in Section 5, the cess was para 5. The explanation to Section 115 shows that the cess was on land revenue and royalty was one element amongst others. For evaluating the total quantum with respect to which the cess will be calculated. It was not a simpliciter cess on royalty. The appellant, then paragraph 10, page 1158. The appellant is bound to pay royalty to the government according to the rates provided in the second schedule to the said Act of 1957. Clause 1 of Part 7 of the lease document provides as follows. The lessee shall pay the rent, water rates, royalties reserved by the lease at such times and manner provided in Part 5 and 6. I have placed this provision already. And 11. As mentioned herein before, there is an obligation of the lessee to pay rent and other charges mentioned in the said clause, and all other central and state government dues except demands for land revenue. The question therefore which arises is cess on royalty a demand of land revenue or additional royalty? One can understand this question as posed, Lord, that because if conclusion is that the cess on, in as so far as royalty is there, the element of royalty goes up. So therefore it's clashing with section 9. One can comprehend that part of it. But as I submitted that in this case, the cess was not on royalty, but cess on land revenue, and royalty was one factor. And kindly come to para 14.
12,
12 is a mention of council.
give us some more clarity.
All right.
Last 6 lines.
For the appellant and or petitioners, we have heard Mr. Nariman, Mr. Chitle, Mr. Salve, and for the interveners, Mr. K.D. Prasad, Mr. Chaudhary, Ms. Sita Vedalingam, have made the submissions for the state of Tamil Nadu. Mr. Krishnamurthy Iyer and Mr. V. Krishnamurthy have made the submissions. We have had the advantage of submissions made by Learned Attorney General on behalf of the Union of India. The issues are common in the writ petitions as well as appeal. The question involved in the appeals in the writ petition is about the constitutional validity of section 115(1) of the Act insofar as it sought to levy as local cess 45 naya paisa on every rupee of the land revenue payable to the government, meaning of land revenue being artificially expanded by the explanation so as to include royalty payable under the mining lease. In this connection, it may be appropriate to refer to the statement of objects and reasons for the amendments which stated inter alia as follows. Under the explanation to section 115 of the Act, land revenue means public revenue due on land and includes water cess payable to the government for water supplied or used for the irrigation of land, but does not include any other cess or surcharge payable under section 116. The explanation does not cover royalties, lease amount, or other sum payable to the government in respect of land held direct from the government on lease or license, which were included in the definition of land revenue under the Madras District Boards Act. As under the Madras District Boards Act 1920, certain Panchayat Union Councils continued to levy the cess and surcharge under the Madras Panchayat Act 1958 also. It is considered that the levy should be on the same basis as under the Madras District Boards Act 1920. It is therefore proposed to include royalty, lease amount, and other sums payable to the government in the definition of land revenue. In the explanation to the section 115 of the Act, and also to validate the levy and collection of the cess and surcharge made hitherto on the said basis. It is obvious that the said amendment was intended to bring royalty within the explanation and definition of land revenue in section 115, as well as section 116, and was effected by Gazette Notification 1964 by Act 18 of 1964. In order to appreciate the controversy, it has to be understood that in this case, royalty was payable by the appellant, which was prescribed under the lease deed, the terms whereof have been noted herein before. The royalty had been fixed under the statutory rules and protected under those rules. The royalty was fixed under the Mines and Minerals Regulation and Development Act 1957, which is Central Act, by which the control of mines and minerals had been taken over by the central government. It was an act for the regulation of mines and development of minerals under the control of India. That act was to provide for the regulation of mines and development of minerals under the control of the Union of India. Section 2 of the Act declares that it is expedient in public interest that Union of India should take under its control the regulation of mines and mineral development to the extent provided in the Act. Section 9 is then quoted. Then para 15, the Act was passed by virtue of powers of Parliament under entry 54 of the 7th schedule. Since the control of the mines and development of minerals were taken over by the Parliament, the question that arises is whether the levy or the imposed by the state legislature imposed in this case can be justified or sustained either under 49, entry 49, 50 or 45 of list 2 of the 7th schedule. Courts of law are enjoined to gather the meaning of the Constitution from the language used, and although one should interpret the words of the Constitution on the same principles of interpretation as one applies to an ordinary law, but these very principles of interpretation compel one to take into account the nature and scope of the Act, which requires interpretation. It has to be remembered that it is Constitution that requires interpretation. Constitution is the mechanism under which the laws are made, and not merely an act which declares what the law is to be. See the observations of Justice Higgins in the Attorney General of State in New South Wales. In re CP and Barar sales of motor spirit, Chief Justice Guare of the Federal Court of India relied on the observations of Lord Wright in James versus Commonwealth and observed that a constitution must not be construed in any narrow or pedantic sense, and that construction most beneficial to the widest possible amplitude of its powers must be adopted. The learned Chief Justice emphasized that a broad and liberal spirit should inspire those whose duty it is to interpret the Constitution, but they are not free to stretch or pervert the language of the enactment in the interest of any legal or constitutional theory, or even for the purposes of supplying omissions or correcting supposed errors. A federal court will not strengthen but only derogate from its position if it seeks to do anything but declare the law. But it may rightly reflect that a constitution of our country is a living and organic thing, which of all instrument has the greatest claim to be construed, ut res magis veliet quam perir. It is better that it should live than that it should perish. Certain rules have been evolved in this regard, and it is well settled that the various entries in the three lists are not powers but fields of legislation. The power to legislate is given by Article 246 and other articles of the Constitution. See the observations of this court in Calcutta Gas Company. The entries in the three lists of 7 scheduled to the Constitution are legislative heads or fields of legislation. These demarcate the area over which appropriate legislature can operate. It is well settled that the widest amplitude should be given to the language of these entries, but some of these entries in different lists or in the same list may overlap and sometimes may also appear to be in direct conflict with each other. Then it is the duty of the court to find out its true intent and purpose, to examine a particular legislation in its spirit and substance to determine whether it fits in one or the other of the lists. See the observations of this court in H.R. Banthia and H.S. Dillon. The lists are designed to define and delimit the respective areas of respective competence of the Union and the states. These neither impose any implied restriction on the legislative power conferred by Article 246 of the Constitution, nor prescribe any duty to exercise the legislative power in any particular manner. Once the language of the entry should be given widest scope to find out which of the meaning is fairly capable of, because these set up machinery of the government, each general word should be held to extend to all ancillary and subsidiary matters which can fairly and reasonably be comprehended in it. In interpreting an entry, it should not be reasonable to import any limitation by comparing or contrasting that entry with any other one in the same list. It is in this background that one has to examine the present controversy. Here we are concerned with cess on royalty. One can have an idea as to what cess is from the observations of Justice Hidayatullah, as the learned Chief Justice then was, in Guruswamy and Company versus State of Mysore, where at page 571, the learned judge observed the word cess is used in Ireland and is still used in India, although the word rate has replaced it in England. It means a tax and is generally used when the levy is for some special administrative expense, which the name health cess, education cess, or road cess, etc. indicates. When levied as an increment to an existing tax, the same matters not for the validity of the cess must be judged of in the same way as the validity of the tax to which it is an increment. The said observations were made in the dissenting judgment, but there was no dissent on this aspect of the matter. Relying on the aforesaid observations, Mr. Nariman, appearing for the appellant, and the petitioner suggested that the impugned levy in this case is nothing but a tax on royalty and is therefore ultra vires of the state legislature. Mr. Krishnamurthy, appearing for the state of Tamil Nadu, submitted that the cess in question in the instant case is a levy in respect of land for every firstling. He urged that the words "a local cess at the rate of 45 paisa on every rupee of land revenue payable" qualify the words land revenue. These words are only intended, according to Mr. Krishnamurthy, to mean cess payable. It is, however, not possible to accept this submission in view of the obligation indicated by the language of the provision. Cess is not on land but on royalty, which is included in the definition of land revenue. None of the three lists of the schedule of the Constitution permits or authorizes a state to impose a tax on royalty. This levy has been sought to be justified under entry 45, list 2 of the 7th schedule. Entry 45 deals with land revenue, which is a well-known concept and has existed in India before the Constitution came into force. In N.R. Reddy, Justice Jagan Mohan Reddy, as the learned judge then was of Andhra Pradesh High Court, while sitting in division bench, observed that no Land Revenue Act existed in the composite state of Madras, nor had the Rayatwari system ever been established by legislative enactment. Learned judge at page 306 of the report observed that in earlier days, sovereigns had, in exercise of their prerogative right, claimed a share of the produce of all cultivated land, known as Raj Bhagam, or by any of the various other names, and had fixed their share or its cumulative money value from time to time according to their will and pleasure. The learned judge noted that as long as the share of the sovereign was being paid, the sovereign had no right to the possession of the lands, and the proprietorship of these land was vested in the occupier, who could not be removed because another offered more. The right of sovereign to share in the produce, as observed by the government of Madras, is not rent, which consists of all surplus produce after paying the cost of cultivation and the profits of agricultural stock, but land revenue only, which ought, if possible, to be so lightly assessed as to leave a surplus or rent to the occupier when he in fact lets the land to others or retains it in his own hands. It was noted that the amount of tax that was levied before the Mohammedan rule, amounting to 1/8, 1/16, 1/12 according to Manu, depending on the differences in the soil and the labor necessary to cultivate it, and it even went up to 1/4 in times of urgent necessity as of war and invasion. The later commentators Yajnavalkya, Apastambh, Gautam, Bodhayan, and Narad have all asserted not only the right but the extent of share. When the British came to India, they followed not only the precedent of the previous Mohammedan rulers, who also claimed enormous land revenue, with this difference that the Mohammedan rulers claimed they could never fully realize, but what the British rulers claimed they realized with vigor. It is not necessary to refer in detail how land revenue developed in India after the advent of the British rules. There was an appeal from the said decision of the High Court, and this court dismissed the appeal in state of AP versus N.R. Reddy. It is, however, clear that over a period of centuries, land revenue in India has acquired a connotative meaning of share in the produce of land, to which the king or the government is entitled to receive. It was contended on behalf of the appellants that the impugned measure, being a tax not on the share of the produce of land, but on royalty, royalty being the return received from the produce of the land. So far there is no argument that royalty is tax versus the share in the produce of land. This is the argument of the petitioners themselves. Revenue was payable for winning materials from the land. In the premises, it was contended that it cannot be attributable to entry 45 list 2 of the 7th schedule, being not a land revenue. It has, however, to be borne in mind that explanation to section 115(1) was added and there was an amendment, as we have noted before. That very explanation makes a distinction between land revenue as such and royalty, which by amendment is deemed to be land revenue. It is therefore recognized by the very force of that explanation and the amendment thereto that the expression royalty in section 115(16) cannot mean land revenue, properly called or conventionally known, which is separate and distinct. It was also contended on behalf of the respondent state of Tamil Nadu, Mr. Krishnamurthy Iyer, that it could also be justified under entry 49 list 2 of 7th schedule as taxes on lands and buildings. This, however, cannot be accepted. In this connection, reference may be made to the decision of this court in Raja Jagannath Baksh Singh, where at page 229 it was indicated that the expression land in entry 49 is wide enough to include agricultural land as well as non-agricultural land. Justice Gajendra Gatkar, as the learned Chief Justice then was, observed that the cardinal rule of interpreting the words used by the Constitution in conferring legislative power was that these must receive the most liberal construction. And if they are words of wide amplitude, the construction must accord with it. If general word was used, it must be so construed so as to extend to all ancillary or subsidiary matters that can reasonably be included in it. So construed, there could be no doubt that the word land in entry 49 list 2 includes all lands, whether agricultural or non-agriculture. Hence, since the impugned act imposed tax on lands and building which was within the competence of state legislature and its validity was beyond challenge, but the court observed that there was entry 46 in list 2, which refers to tax on agricultural income. It is clear that agricultural income is not included in 49. If the state legislature purposed to impose a tax on agricultural income, it would be referable to entry 49. Mr. Krishnamurthy Iyer relied on the said principle, but in the instant case, royalty being that which is payable on the extraction from the land and cess being an additional charge on royalty cannot by the parity of the same reasoning be considered to be a tax on land. But since it was not a tax on land and there is no entry like 46, in the instant situation, like the position before this court, in the aforesaid decision enabling the state to impose tax on royalty, in the instant situation, the state was incompetent to impose a tax. There is a clear distinction between tax directly on land and tax on income arising out of the land. It is here not that Mr. CJI says that this was enough to strike it down because it's a tax on income. And it is state's own income which it is taxing. But this judgment does support, so far as entry 49 list 2 is concerned, that it is to be very widely construed and includes all types of land. The aforesaid decision confirmed the above position in new Manik Chowk spinning and weaving mills. This court, after referring to the several decisions, observed that entry 49 or list 2 of the 7th schedule only permitted levy of tax on land and building. It did not permit the levy of tax on machinery contents in or situated on the building, even though the machinery was there for the use of the building for a particular purpose. Rule 7.2 of the Bombay Municipal Corporation rules was also held to be accordingly ultra-virus in the said case. In SC non, this court had occasion to consider this and upheld the validity of Wealth Tax Act on the ground that it fell within entry 86 and not entry 49 of list 2. Construing the said entry, this court observed that entry 49 contemplated a levy on land as a unit, and the levy must directly be imposed on land and must bear a definite relation to it. So this is the case which drew the distinction between a composite tax under 86, list 1, and land as a unit, which means it should be only on land, not on all other assets. In Assistant Commissioner of Urban Land Tax versus Buckingham and Karnataka Company, this court reiterated the principles laid down in SC Non's case and held that entry 49 of list 2 was confined to tax that was directly on land as a unit. In second gift tax officer versus Nazareth, it was held that tax on the gift of land is not a tax imposed directly on land, but only on the particular user, namely the transfer of land by way of gift. In Union of India versus Dhillon, this court approved the principle laid down in Non as well as Nazareth. In Bhagwan Das Jain, this court made a distinction between levy on income from house property, which would be referable to entry 49 list 2. It is therefore not possible to accept Mr. Krishnamurthy's submission that the cess on royalty cannot possibly be said to be a tax or an impost on land. Mr. Nariman is right that royalty which is indirectly connected with land cannot be said to be taxed directly on land as a unit. In this connection, a reference may be made to the differentiation made to the different type of taxes for instances, one being professional tax and entertainment tax. In Western India theatres, it was held that the entertainment tax is dependent upon whether there would or would not be a show in cinema house. If there is no show, there is no tax. It cannot be a tax on profession or calling. Professional tax does not depend upon the exercise of one's profession, but only concerns itself with the right to practice. It appears that in the instant case also, no tax can be levied or is leviable under the impugned act if no mining activities are carried on. Hence, it is manifest that it is not related to land as a unit, which is the only method of valuation of land under entry 49 of list 2, but is relatable to minerals extracted. Royalty is payable on a proportion of the minerals extracted. It may be mentioned that the Act does not use dead rent as the basis on which land is to be valued. Hence, there cannot be any doubt that the impugned legislation in its pith and substance is a tax on royalty and not on land. Now, in my humble submission, note, this is completely erroneous, because your Lordship saw in 9A that dead rent or royalty in the alternative, whichever is higher. The court seems to be saying, had it been dead rent instead of royalty, it would have been all right. But since royalty has been brought there, therefore it is. And the other aspect, note, is that since it is dependent upon use, now the fact that land is being used or not used, note, can be a classification method, because government will not like to tax the land where for some good reason mining is not being done. So it's not always that once the aspect of user comes in, therefore it automatically goes out of the fold of entry 49, list 2. Then kindly come to 24 at page 116. On behalf of the state of Tamil Nadu Learned Council, Mr. Krishnamurthy Iyer sought to urge that it can also be sustained under entry 50 list 2. Entry 50 of list 2 of the 7th schedule deals with taxes on mineral rights, subject to limitation imposed by Parliament relating to mineral development. Entry 23 of list 2 deals with regulation of mines and mineral development subject to the provisions of list 1. With respect to regulation and development under control of the Union, and entry 54 in list 1 deals with regulation of mines and minerals under the control of the Union declared by Parliament by law to be expedient in public interest. Even though minerals are part of the state list, they are treated separately. And therefore, the principle that the specific excludes the general must be applied. See the observations of Waverley, Jute Mills, where it was held that land in entry 49 cannot possibly include minerals. Please mark this sentence, my lords. It will not include minerals, not that it will not include the land itself. In this connection, learned Attorney General appearing for the Union of India submitted before us that in order to sustain the levy, the power of the state legislature has to be found within one or more of the entries of list 2 of the 7th schedule. The levy in question has to be either a tax or a fee or an impost. If it is neither a tax nor a fee, then it should be under one of the general entries under list 2. The expression land, according to its legal significance, has an indefinite extent both upwards and downwards the surface of the soil, and would include not only the face of the earth, but everything under it or over it. Now, this is in support of the states. It doesn't go against. See the observations in Anant Mills. The minerals which are under the earth can, in certain circumstances, fall under the expression of land. But as tax on mineral rights is expressly covered by entry 50 list 2, if it is brought under the head taxes under entry 49 of list 2, it would render entry 50 of list 2 redundant. Learned Attorney General is right in contending that the entry should not be so construed as to make one entry redundant. It was further argued that even in pith and substance, the tax fell to entry list 50 list 2. It would be controlled by a legislation under entry 54 list 1. Now, there is only one problem with these observations, that Mr. Krishnamurthy wanted to justify the tax in the alternative under entry 50 list 2, saying therefore that it can be, cess on royalty can be understood since royalty is relatable to extracted mineral and dispatched mineral. Therefore, it is very proximate in nexus with entry 50 list 2. Now, what the court is saying that the minerals which are under the earth can in certain circumstances fall under the expression land. So if it either falls under land or it falls as a mineral right. So either it goes under 49 list 2 or it comes within the fold of entry 50. If it comes under 50, then the state is competent subject to the limitations. On the other hand, Learned Attorney General submitted that if it be held to be a fee, then the source of power of the state legislature under entry 66, read with entry 23 list 2, here also the extent to which regulation of mines and mineral under the control of the union is declared by parliament by law to be expedient in public interest, to the extent such legislation makes provision, will denude state legislature of the power to override the provision of entry 50 list 2. Now, this again, Millard, in my humble submission, is completely erroneous. 54 will not denude, it will not enable Parliament to arrogate to itself any power of tax. In view of the parliamentary legislation under entry 54, declaration made under section 2 and provision of section 9 of the Act, the state legislation would be overridden to that extent. It's completely erroneous in my respectful submission. Because it assumes that section 9 is a tax and tax pertaining to entry 50 list 2, and it is a limitation on that, and therefore denudation happens. Then they refer to Hingir Rampur and also the observations of state of Odisha versus Tulak. Our attention was drawn to the decision of the division bench judgment of the High Court of Mysore in Lakshmi Narayan Mining Company. There, speaking for the court, one of us, Justice Venkatramaya of the Mysore High Court, as the learned Chief Justice then was, observed that a combined reading of entry 23 and 50 of list 2 and entry 54 establishes that as long as the Parliament does not make any law in exercise of its power under entry 54, the powers of the state legislature in entry 23 and 50 would be exercisable by the state legislature. But once the Parliament makes a declaration by law that it is expedient in the public interest to make a regulation of mines and minerals development under the control of the Union to the extent to which such regulation and development is undertaken by the law made by Parliament, the power of the state legislature under 2023 and 50 list 2 are denuded. 23 is understandable. But entry 50, unless one finds a specific express limitation in the MMDR Act made under entry 54, will not be either denuded or abstracted for me. Abstraction is absolutely not possible. Limitation is possible.
So this has to be read in the context of the facts of that case. There it was a license
License
fee.
fee.
A license fee was held to be royalty. But here, the interpretation of that judgment is very wide.
Yes. That has led to the errors in this case. I'm grateful. I'll place that case also before your Lordship. To the similar effects of the observations of the High Court of Patna, that High Court of Patna, this para I'm not reading because Patna has been followed in the Karnataka case, and when I place that Mysore case, then in para 29, HRS Murthy is referred, and this was overruled by this 7 judges judgment. So let me place this extracted part of HRS Murthy. When a question arises as to the precise head of legislative power under which a taxing statute has been passed, the subject for inquiry is what in truth and substance is the nature of the tax. No doubt, in a sense, but in a very remote sense, it has a relationship to the mining as also to the mineral won from the mine under a contract by which royalty is payable on the quantity of mineral extracted. But that does not stamp it as a tax on either the extraction of the mineral or on mineral right. It is unnecessary for the purpose of this case to examine the question as to what exactly is the tax on mineral rights, seeing that such a tax is not leviable by Parliament, but only by the state, and the sole limitation on the state's power to levy the tax is that it must not interfere with a law made by Parliament as regards mineral development. Our attention was not invited to the provisions of any such law created by Parliament. In the context of section 78, 79 and the scheme of those provisions, it is clear that the land cess is in truth a tax on land within entry 49. So HRS Murthy did not see section 9 as a tax or a limitation on entry 50. It seems, therefore, that the attention of the court was not invited to the provisions of the Mines and Mineral Development and Regulation Act and Section 9 thereof. Section 9(3) of the Act in terms states that royalties payable under the second schedule of the Act shall not be enhanced more than once during the period of 4 years. It is therefore a clear bar on the state legislature taxing royalties so as to, in effect, amend second schedule of the Central Act. In the provision, it cannot be right to say that tax on royalty can be a tax on land. And even if it is a tax, if it falls within entry 50, it will be ultra vires the state's legislative power in view of section 9(3). In Hinger Rampur versus State of Odisha, Justice Vanchu in his dissenting judgment has stated that a tax on mineral rights being different from duty of excise pertains only to a tax that is leviable for the grant of right to extract minerals and is not a tax on minerals as well. On that basis, a tax on royalty would not be a tax on mineral rights and would therefore, in any event, be outside the competence of the state legislature. The Rajasthan, Punjab, Gujarat, and Odisha High Courts have held that royalty is not a tax. See, so and so, so and so, so and so. It was contended. Now there is no discussion of these judgments at all, Manoj.
Right.
As to what they have held, what is their logic, and what is the fallacy in those judgments. In fact, in Dr. S.S. Sharma's case, which I'll be placing, the validity of Section 9 had been questioned. That this is a tax and it's a usurpation of the power under 50. So the court said it's not a tax and therefore there's no question of usurpation. That's how it was said. Then 32, it was contended by Mr. Krishnamurthy that the state has a right to tax minerals. It was further contended that if a tax is levied, it will not be irrational to correlate it to the value of the property and to make some kind of annual value basis of tax without intending to tax the income. In view of the provisions of the Act as noted herein before, this submission cannot be accepted. Krishnamurthy also further sought to urge that entry 50, there is no limitation to the taxing power of the state. In view of the principles mentioned herein before and express provision of Section 9(2) or MMRD Act, this submission cannot be accepted. The field is fully covered by the central legislation. In any event, royalty is directly relatable only to minerals extracted. And on the principle that the general provision is excluded by the special one, royalty would be relatable to entry 23 and 50 list 2 and not entry 49 list 2. But as the fee is covered by the central,
Is it the field, I think, but as the field is covered.
fee is covered by the central power,
Field.
FEE, fee.
FIELD. It's a
Field.
typo.
Oh, yes.
Here it is a typo.
Where is the typo?
Here it is a typo.
That also is.
As the field is
But
covered
as
by.
the field is covered by the central power under entry 23 of or entry 50 of list 2, the impugned legislation cannot be upheld. Our attention was drawn to a judgment of the High Court of Madhya Pradesh, Hiralal Rameshwar Prasad, which was delivered by a division bench. Justice J.S. Verma, acting Chief Justice, as his lordship then was, held that the development cessed by so-and-so is ultra virus. It is not necessary to, in the view taken by us further.
Yes, oh my God.
So just pausing, my lord, up till para 33, there is no discussion, no debate, no issue raised by any side that royalty is a tax or not. Just the Mysore High Court judgment is referred and then the 4 High Courts holding otherwise is referred. Neither of them are discussed. Because if there are 2 sets of reasoning, my lord, it would be expected, my lord, if a bench of 7 judges to discuss and debate, my lord, which one is the right one.
No, earlier it was Karnataka.
And why Mysore should be adopted instead of the other 4. In fact, the 7 judges bench has avoided the question which of them is right. So my learned friend is not quite right in saying that while getting up the judge said, my lord, and obviously that is not on record, my lord, that it is this or it is that. At least I was not there, my lord, so I will go by the record. Now kindly see, my lord, the abrupt conclusion in the
Most
passage.
crucial paragraph.
34.
34 is the most crucial paragraph.
In the aforesaid view of the matter, we are of the opinion that royalty is tax. As such, cess on royalty being a tax on royalty is beyond. One can understand cess on royalty being a tax on royalty is beyond the competence. One can understand that part. But there was no issue. Issue was whether cess on royalty is good or bad. And the court is saying in the aforesaid view of the matter. So there is no view of the aforesaid matter in the previous paragraphs. Not a single sentence, not a whisper. And that's why Kesharam said, Milord, that if you say just this word is missing, in the aforesaid view of the matter, we are of the opinion that cess on royalty is a tax.
Correct.
So that's how, Milord, this clarified this apparent error. There was no issue. No issue has been framed in any paragraph that whether royalty is a tax or not. There is no debate, no consideration of the general concept of
If you
royalty.
read it like that, see, it's so obvious. In the aforesaid view of the matter, we are of the opinion that royalty is a tax. Now we'll just leave that aside because those are the disputed words.
Yes.
Now see what follows.
As such,
As
cess
such,
on royalty.
a cess on royalty being a tax on royalty. So the next phrase makes it
That's
very
right.
clear that what they were saying is
That
that
was the issue.
a cess on royalty is a tax
Is a
on
tax.
royalty.
The royalty was.
That's all that which Kesharam has tried to make it straight, consistent. And this sentence, well, the first part of the sentence has been picked up in a number of cases down the line and they all went astray.
Sentence clarified actually.
Now see the second and third sentence. In any event, we are.
On royalty. So they tried to repeat what they had said earlier in the second part of the same sentence in order to draw the conclusion is beyond the competence of the state legislature.
In any event, we are of the opinion that cess on royalty, they come back to cess on royalty, cannot be sustained under entry 49 list 2 as being tax on land. Royalty on mineral rights is not a tax on land, but a payment for the user of land. So this is what we are saying, that the last sentence is supporting, which I had been submitting since morning, that royalty is for not merely user. I would say even this is not fully correct, because the royalty is for transfer of the owner's right to extract the mineral and sell it. So the mineral value has to be shared by the owner and the lessee. One is the lesser is the dominant owner and the lessee is the subservient owner.
Yes.
Having an interest in land because of the lease. So therefore, it's logical that the mineral value which is state is owning must be shared with the only the sharing mode is prescribed by Section 9. So I am not standing up to defend a cess on royalty simpliciter. Though in this case, it was a cess on land revenue by virtue of explanation, royalty was one additional factor. Even otherwise, with utmost deference to the learned judge, I submit that even if royalty, there was a problem, then that word could be struck down, though not the whole section which said cess on land revenue, including water charges and so on and so forth. Especially,
Orissa, for example, is straight on, cess on royalty.
we'll come to Odisha, don't worry. Right now I'm in Jharkhand. So in this case, the cess was not on royalty directly, but a cess on land revenue. Normally it's something like surcharge. It takes the same character.
उसके बाद पर्सपेक्टिविटी की बात
In this paragraph 34,
Yes,
it reads somewhat abruptly
that's right.
because we are not able to sort of connect with the previous paragraphs,
Yes.
the logic or the reasoning. Anyway, I'm sure.
It's an abrupt conclusion without any issue being there, without any contention being there, and without any debate or consideration of the concept of royalty as it exists. One may arrive at a conclusion that in other matters, royalty may be a consideration or a return to the owner, but in the context of mining, it is not so. But there is no debate, no consideration of that at all.
In fact, Justice Oja says whether royalty is a tax or not is not very material for the purpose of determination of this
Yes.
question.
That's exactly what
That's right.
I'm pointing out.
That's right. Further paragraph.
Out about the conclusion that the court
But
reached.
Justice Oza's judgment goes further down the street. I mean, if we accept Justice Oza, then every tax has got some land. Every business has got land. Every business is based on capital. Every business is based on labor. So this formula that a tax is on land plus capital plus labor, I mean, this is. So every tax which is being imposed on capital assets or whatever, the sale tax and so on, the excise duty, on manufacture. So no manufacturing can happen unless there is a capital, unless there is labor, and the factory is standing on some land and based on raw material.
On cess,
But what is
on cess, there is a dissenting opinion of Justice Vanchu in Hingir Rampur.
India Rampur? My lords are right.
Says if you just because you make a fund for certain infrastructure development and you call it a cess, it doesn't mean that it is different from royalty.
That's
That
right.
is what he says.
I'll place Hingir Rampur also.
Yes.
Lordship is right.
Called it excise duty.
Yes, on manufacturer, extraction of
Yes.
minerals as
Actually,
manufacture,
but-
entry 86,
Yes. 84.
84 list 1.
Excise duty.
And the problem is in the next sentence, where he says,
Yes.
he says if you levy it with reference to royalty, royalty is real, if you levy it with reference to production, it's an excise duty. Majority says that's a measure. They went by that subject. He says, no, this is an excise duty. And then he says royalty is a tax on mineral rights, but royalty is also charged with reference to production. Then that is why India Cements at one place says when it is dealing with one Chuche, that then royalty is also not a tax. It will be excise duty. Because if anything is collected on the basis of actual production, it becomes manufacture according to Justice Vanchu's logic.
So we are yet not.
That is why, my lord, we are best 9 of your lordships hear these without being.
Yes.
The conclusion is Vanchu.
Just see para 40. Yes, of Justice Oza's judgment concurring. Whether royalty is a tax or not is not very material for the purpose of the determination of this question. In this case, it is admitted that royalty is charged on the basis of per unit of minerals extracted. It is no doubt true that mineral is extracted from the land and is available, but it could only be extracted if there are 3 things: land, capital, labor. It is therefore clear that unit of charge of royalty is not the land, but land, labor, capital. It is therefore clear that if royalty is a tax or an imposition or a levy, it is not on land alone, but it is a levy or a tax on mineral, labor, capital employed in extraction of the mineral. So even if we take this sentence as it is, my lord, it will be both land and mineral. So both entry 49 and entry 50 will be attracted. It therefore is clear that royalty, if it is imposed by Parliament, it would only be a tax not only on land but on these 3 things stated above. Now this is based on if royalty. Royalty, if it is imposed by Parliament as a tax. It is not in dispute that the cess which the Madras Village Panchayat proposes to levy is nothing but an additional tax, and originally it was levied only on land revenue. Apparently, land revenue would fall within the scope of entry 49. This is erroneous. It will be entry 45, land revenue. But it could not be doubted that royalty, which is a levy or tax on the extracted mineral, is not a tax or a levy on land alone, and if cess is charged on the royalty, it would not be said to be a levy or tax on land, and therefore it could not be upheld as imposed in exercise of jurisdiction under entry 49. Thus, it is clear that by introducing this explanation to section, widening the meaning of the word land revenue for the purpose of section 115 and 16, when the legislature included royalty, it went beyond its jurisdiction under entry 49 list 2 and therefore clearly is without the authority of law. But this also may lead to an interesting situation. This cess levied under so-and-so was intended to be levied on all lands falling within the area. But as this cess on royalty is without the authority, the result will be that the cess is levied so far as lands other than lands are situated are concerned. But lands where mines are situated, this levy of cess is not in accordance with that law. This anomaly could have been averted if the legislature in this explanation had used the word surface rent in place of royalty. Even if the lands where mines were situated and which are subject to license and mining leases, even for those lands, there is a charge on the basis of surface of the land, which is sometimes described as surface rent or sometimes also dead rent. Although the two are different concepts, dead rent and surface rent. It could not be doubted that if such a surface rent or dead rent is charged or an imposition on the land only and therefore will clearly fall within the purview of 49 list 2, and if excess is levied on that, it will also be justified as tax on land. So had it been surface rent and dead rent, then it is justified under 49, but not all.
What next, Mr. Dedi?
Now there are two cases in between, my lord. One is Odisha Cement. Same volume, page 1329. उसमें से
How it is in.
Now, paragraph 3 suggests this is also a case of cess on royalty. Para 8, the lordships refer to the dissenting judgment of Justice Vanchu in Hinge Rampur. That's referred to in para 8.
Section 7(3) of the Odisha
Kindly come to page 1350, where the section under challenge is quoted, section 5 and then section 7. The bottom of the page 1350, the rate per year at which such cess shall be levied. If I may read the top, my lord, the rate of cess. Roman 2, the rate of cess assessment and fixation of cess year are dealt with by section 5, which reads, the cess shall be assessed on the annual value of all lands on whatever tenure held calculated in the manner hereinafter appearing. The rate per year at which cess shall be levied will be 25% of the annual value of the land. Now at page 1351 towards the bottom, section 7 defines annual value. The annual value of lands held by rayats shall be the rent payable by such rayat to the landlord. 2. In the case of lands held as an estate, the annual value shall be the aggregate of the amount which the intermediary is entitled to receive on account of revenue or rent, less the amount payable by an intermediary as revenue to the intermediary immediately superior to him or to the government, as the case may be. B. The rent, if any, payable under the land or in the khas possession. 3. In the case of lands held for carrying on mining operations, the annual value shall be royalty or, as the case may be, the dead rent payable by the person carrying on mining operations to the government. And then section 9B, in between placitum D, 7.3 is there. In the case of lands held for carrying on mining operations, annual value shall be the land, as the case may be, the dead rent payable by the person carrying on mining operations to the government, or the pit mouth value, wherever it has been determined. Please come to page 1370. In the previous paragraphs, there are discussions or references to India Cement. I am leaving that because I have placed the judgment. There has been considerable discussion before us as to whether royalty itself is a tax or not. The controversy before us centers around the discussion contained in para 31 to 34 of India Cement. Judgment Counsel for the assessee respondents invite attention to the opening sentence of para 34, which runs, in the aforesaid view of the matter, we are of opinion that royalty is tax, and argue that this clinches the issue. On the other hand, CJI submits that this purported conclusion does not follow from the earlier discussion and is also inconsistent with what follows. He points out that though there is reference in para 27 to the conclusion of Justice Venkat Ramaiah in a judgment of the Mysore High Court that royalty under section 9 is really a tax, and a reference in para 31 to Rajasthan, Punjab, Gujarat to the effect that royalty is not a tax, there is no discussion, criticism or approval of any of the decisions on this point, and that therefore the first sentence of para 34 is non sequitur. He submits that perhaps there is typographical error in the first sentence of para 34, and the sentence should really read thus. So here the sentence is completely suggested in a different form. He also points out that the last sentence of para 34 reads, royalty on mineral rights is not a tax on land, but a payment for the user of land. He submits, therefore, that this issue has not been decided in India Cement. He submits that before we express any opinion on this issue, we should consider the matter afresh, and places before us extracts from various lexicons and dictionaries to show that royalty is nothing more then the rent or a lease amount payable to the lessor in consideration for the grant of lease to exploit minerals. Reference may also be made to D.K. Trivedi, para 35 so and so. It is therefore neither a fee nor a tax, but merely a price paid for the use of mineral bearing land. We do not think it is necessary for us to express an opinion either way on this controversy, for it seems to us it is immaterial for the purpose of the present case. If royalty itself were to be regarded as a tax, it can perhaps be described properly as a tax on mineral rights. And has to conform to the requirements of entry 50, which are discussed later. We are, however, here concerned with the validity of the levy of not royalty but of cess. If the cess is taken as tax, then unless it can be described as land revenue or a tax on land or a tax on mining rights, it cannot be upheld under entry 45, 49 or 50. On the contrary, if it is treated as a fee, the state's competence to levy the same has to be traced to entry 23, a proposition the effect of which will be considered later. The question whether royalty is a tax or not does not assist us much in furnishing an answer to the two questions posed in the present case and set out earlier. We shall therefore leave this question to rest here. So it's not that for the first time suddenly, but the subsequent benches also this issue, and the learned judges obviously did not deal with that issue in this.
See, how long now, Mr. Any reassessment of the time that you're likely to take?
We'll finish tomorrow.
Sorry?
I'd like to finish tomorrow, but I'll try to finish tomorrow.
Maybe everyone can now make a reassessment of the time they're going to take and then give us a fresh assessment.
Yes.
Would about lunch be all right for you tomorrow, Mr.?
Lunch will not be possible.
If their side finishes tomorrow, then our side can start on Thursday.
No, that's not possible. That's not possible.
Day after lunchtime.
This week, let it be. This week, this time.
There are many
This week,
states.
no, this week will be too long for this side. I think now Mr. Dwivedi has covered a very large part of his submission.
So some part which is not covered with Mr. Dwivedi only can be supplemented.
We were thinking tomorrow, this side can conclude. At the most, maybe 1 hour day after tomorrow, and then the other side can start. We can give you time until 11:30 on 11:30 on Thursday, isn't it?
Perfect.
So by 11:30 on Thursday, I think this side can conclude. So please ration out the time between yourselves so that by 11:30 the baton passes on to this side. Everybody between you 11:30 on Thursday. So by 11:30 we'll start with this side.
I think, but at the most by 11.